On Monday evening, federal Judge Aileen Cannon issued perhaps the most bizarre and also dangerous order I've ever seen in my legal career, and many of the legal commentators and legal experts who I respect the most feel the exact same way. It seems to me that Judge Aileen Cannon is trying to set a trap for Special Counsel Jack Smith to try to use Judge Cannon's words, engage with hypothetical scenarios that Judge Cannon puts out there for potential jury instructions. And I'll go through this in a moment, whereby under both scenarios, Judge Cannon claims that under the Presidential Records Act, Donald Trump can have special access to our national defense information when he leaves office. And under one of the two scenarios, simply by packing up records and putting them in a box and shipping them to Mar-a-Lago, whether they are nuclear codes, classified information, war plans, top secret information, whatever it is, that by Donald Trump saying it belongs to him personally, that then Donald Trump can keep it that way and federal judges can't even do anything about it. But she wants Special Counsel Jack Smith and Donald Trump's lawyers to use these hypotheticals now to craft potential jury instructions, despite the fact that Judge Aileen Cannon previously even rejected Special Counsel Jack Smith's request to set this trial for July, and she seemed to lean towards what Donald Trump was requesting, to set this trial for sometime in 2025. Let's just go through this order. Let's break it down. Let me show you what I think she's doing here. Order requiring preliminary proposed jury instructions and verdict forms on counts 1 through 32 only. And counts 1 through 32 involve violations of 18 U.S.C. Section 793 against Donald Trump. This is for the willful retention of national defense information. And one of the arguments Donald Trump had previously made is that 18 U.S.C. Section 793 is unconstitutionally vague. The statute that was put into law in 1917, Trump argues, is unconstitutionally vague. And previously, Judge Cannon ruled that without prejudice, she was going to reject Donald Trump's claim without prejudice, but thinks he raises really good points that she wants to bring up in the future with jury instructions. And that's what she said last week. So now she's talking about jury instructions, because one of the other things that Donald Trump argued, and he had Stephen Miller file an amicus brief or a friend of the court brief, is arguing that under the Presidential Records Act, that Donald Trump would be permitted to classify on his own, one, telepathically declassify things, and then claim anything he wants that belongs to we the people. And I'm talking nuclear codes. I'm talking about highly classified information as Donald Trump's personal property. Let's go through what this order says. Order requiring preliminary proposed jury instructions and verdict forms on counts 1 through 32 only. On or before April 2nd, 2024, defendant Trump and the special counsel each shall file proposed jury instructions limited to the essential elements of the offenses charged in counts 1 through 32 of the superseding indictment, along with proposed verdict forms for those counts, general or special. And there's a footnote. Instructions beyond the substantive contours of counts 1 through 32 are not part of this order, but defenses inextricably intertwined with the statutory definitions are so contained, the standard 20-page limit for memorandum of law does not apply to the ordered submissions. Like, what is she even talking about here? Judge Cannon goes on to say, moreover, understanding that juries are judges of the facts, not the law, the proposal shall take care to specify in incorporated briefing as necessary exactly what factual questions are reserved for the jury on counts 1 through 32 in light of the recently argued motions to dismiss. And there she's talking about the motion to dismiss on Trump's claim that the 1917 statute is unconstitutionally vague. And then Donald Trump's other argument that under the Presidential Records Act, he could claim these classified documents as his personal property by simply packing it up and shipping it to Mar-a-Lago. With respect to the proposed language pertinent to the issue of, quote, unauthorized possession, specifically, the parties must engage with the following competing scenarios and offer alternative draft text that assumes each scenario to be a correct formulation of the law to be issued to the jury while reserving counterarguments. Now, folks, this is not normal stuff. Like, what she's asking the parties to do here at this stage makes absolutely no sense. So she's saying with respect to proposed language pertinent to the issue of unauthorized possession, and she puts that in quotes. What's the quote there? Trump's not authorized to have these documents when he's out of office, or nobody is. She goes, the parties must engage with the following competing scenarios. What do you mean engage with them? Talk about them, play with them, think about them? I mean, is this a law school exam? Like, what do you mean engage with them? And then it goes, the parties must engage with the following competing scenarios and offer alternative draft text that assumes each scenario to be the correct formulation of the law to be issued to the jury while reserving counterarguments. Now, here are the two scenarios that she wants the parties, and Special Counsel Jack Smith and Trump, to assume as correct. Both are incorrect. Both are very false. So she wants Jack Smith to engage with two very false scenarios here. A, in a prosecution of a former president for allegedly retaining documents in violation of 18 U.S.C. Section 793E, a jury is permitted to examine a record retained by a former president in his or her personal possession at the end of his or her presidency and make a factual finding as to whether the government has proven beyond a reasonable doubt that it is personal or presidential using the definitions set forth in the Presidential Records Act. So that scenario right there is already a false, unlawful, incorrect statement of the law. In prosecution of a former president, doesn't matter. He's now a regular citizen. He's citizen Trump now, not former President Trump. He doesn't get extra rights once he leaves that office. That's the way our democracy works. And it goes, in a prosecution of a former president for allegedly retaining documents in violation of 18 U.S.C. Section 793E, a jury is permitted to examine a record retained by a former president in his or her personal possession at the end of his or her presidency and make a factual finding as to whether the government has proven beyond a reasonable doubt that it is personal or presidential. What are you talking about? When the presidency ends, you return the documents. They don't belong to you anymore. They belong to, you don't get to steal nuclear codes and classified documents. So that scenario is false. Then this is the other scenario they want Jack Smith and Trump to engage with. A president has sole authority under the Presidential Records Act to categorize records as personal or presidential during his or her presidency. Neither a court nor a jury is permitted to make or review such a categorization decision. Although there is no formal means in the PRA by which a president is to make that categorization, an outgoing president's decision to exclude what he/she considers to be personal records from presidential records transmitted to the National Archives and Records Administration constitutes a president's categorization of those records as personal under the PRA, done and ordered in chambers on the 18th day of March, Judge Aileen Cannon. Like, what is this order even supposed to relate to? And then that second scenario. So the first scenario, scenario A, Judge Cannon wants the parties to accept as correct that in a prosecution of a former president for allegedly retaining documents, a jury is permitted to examine these records to then make the factual finding whether the government has proved beyond a reasonable doubt that it's personal or presidential. That's just not a correct statement of the law. And then B, they want Jack Smith, she wants Jack Smith and Trump, but to both accept as true that a president has sole authority to telepathically declassify documents and then claim that there are to claim that our nuclear codes, our war plans, national defense information, classified records, just because a former president says so, it then belongs to them, becomes their personal property when you put it in a box and ship it to Mar-a-Lago. So that's why I think Judge Cannon, if you now look at this order in its full context, I think she's setting up a trap here, because if Special Counsel Jack Smith responds to either of these scenarios, both are incorrect. He should engage with neither of these scenarios, and I think basically say, I'm not going to respond to scenario A. I'm not going to respond to scenario B, because that would be unlawful to respond to both of these scenarios, because both are false. The correct scenario should simply be, the Espionage Act has been around since 1917. These cases have been tried throughout the country. There are model jury instructions that a jury gets when you have a case involving Espionage Act violations. You use the jury instructions. That's what the jury is instructed on. There's no special jury instructions for former presidents. There's no special jury instructions that involve telepathically declassifying and then taking classified records and converting them into personal property. Our war plans, our nuclear codes do not become personal property. That's the opposite of what the Presidential Records Act states. And I understand that Stephen Miller and these right-wing groups have submitted amicus briefs to Judge Aileen Cannon claiming that Trump has the right to telepathically declassify or claim presidential records are his personal property, claim national defense information. But that's simply not what the law is. That's incredibly dangerous. And so I think my question, if I'm Special Counsel Jack Smith right now, is, can you view what Judge Cannon did here, because she's now just saying, respond to these two things, that they're both unlawful. I mean, this is such a bizarre and unprecedented order that, like, I can't say, oh, well, when this has happened, this definitely means you can do an interlocutory appeal. But I wonder if Special Counsel Jack Smith now looks at this and says, as a special counsel, as a prosecutor, I can't respond to either of these scenarios, because both scenarios are legally defective. Appeal to the 11th Circuit, because we can't respond to two patently unlawful scenarios, and both scenarios showing that Judge Aileen Cannon has no basic understanding in this area and is so dangerous to be involved in this case. And I think, look, I mean, this is such an egregious and weird order that I could only, that I think the 11th Circuit would have very, very, very would take a very strong position against Judge Cannon on this, and even potentially remove her from the case. The thing that, I think that Jack Smith and his team are researching right now is, like, with something like this, is this an appealable, like, what is this? Like, this is a very strange thing. Like, what even is this? But I wanted to give you the breakdown there. Tell me what you think in the comments, but I read this as a trap. Have Jack Smith try to respond to two things that are false. So he almost buys into two false frameworks, and then she'll adopt one of the frameworks, give that to the jury and be like, oh, well, the government adopted the framework. But it's so obvious that's what she's doing. Jack Smith is going to understand that. He's not going to buy into this. The question is it appealable? Or does he in his motion just say, we are unable to provide or engage with either scenario because both violate clearly established law? Watch for Jack Smith's response, because you're going to see one of those two things. Hit subscribe. We're on our way to 3 million subscribers. Thanks to your support, and have a wonderful day.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.